My name is Stephanie Zepka. I represent Defendant Otis Elevator Company. We're not a party to any of the motions today. I'm just here observing.
So 2101 Rio is an apartment complex in Austin over by the University of Texas. And in 2021, on September 15th, the plaintiffs, John Herring and Lucero Salceda, were allegedly in an elevator that entered a free fall for a little while. They got out and went and talked to the property manager, who was a woman named Margot Mendoza, and then subsequently filed this lawsuit. At the time, Lucero Salceda was actually also a resident of the apartment and an employee of CA Ventures, I believe, which is one of the defendants. Plaintiffs originally sued Margot Mendoza individually and then later amended and added 2101 Rio property owner, Campus Acquisitions, CA Ventures, and Otis Elevators. Rio, for my part, is solely the property owner. They're not involved in the day-to-day operations of the property. They have a contract with, or had a contract with Campus Acquisitions Management LLC for Campus Acquisitions to manage the property. And that contract was entered into in 2014. Campus Acquisitions then is the property management company, and they worked with CA Ventures, who I think is the employing entity or one of the employing entities for the actual employees on the ground at the apartment complex. Campus Acquisitions, as the property management company, then turned around and signed a contract with defendant Otis Elevator Company for Otis to provide maintenance and is determined to be necessary by Campus Acquisitions, troubleshooting, repair services, passenger services, and for all of the elevators. And this makes sense because you don't want a bunch of leasing agents and apartment maintenance guys tinkering with the elevators, right? This is student housing. There's college kids working there. The elevators are the exclusive realm of Otis Elevators. So Rio, for its part, is 3 steps removed from any level of control in actuality on the property at any given time. Now, their contract with Campus Acquisitions does provide that they have the option to give instruction to Campus Acquisitions, and of course they would. It's their building, but the reality is that the management agreement designates Campus Acquisitions as the managing agent for day-to-day operations, and the elevator maintenance contract is between Campus Acquisitions and Otis. Rio is not a party to that, and in this instance, we've got an entity that's been sued for negligence and premises liability, but it isn't even present on the property. Before we actually get into the actual causes of action, I'll let Dylan fill you in on Campus Acquisitions and CA Ventures' role in this, since he's taking that portion of it.
Yeah, Judge, and Mr. Sherrod pretty much summed everything up. That I don't have too much to add, just that CA Ventures and Campus Acquisitions, I'm just going to call for brevity's sake, the CA defendants. They were the operational entity at the property at the time, and as Colin said, they licensed the operation. I shouldn't say licensed, they contracted the management, the operation, the repairs, basically the total operation of the elevator to Otis Elevator Company, with the caveat that they were supposed to report any issues of the elevator to Otis. And that basically is the end of duty, is that if there's an issue with the elevator, shut it down, report it to Otis. Otis is the expert. Otis is the elevator company. As Colin was saying, you don't want college kids operating an elevator and trying to tinker with various parts of the elevator. That in itself, I think, would be negligent not to go to the expert elevator company. In this case, whenever there was an instance or an issue of a malfunction or something noted by a tenant, and even in this case, Lucero Salcedo and Mr. Herring, when they came to the property manager noting the issue that had occurred, the property manager was notified. They shut the elevator down. They notified Otis. Otis came out, inspected the issue, and that's what they had done previously in every instance there was an issue. Therefore, their duty, the only duty they may have had, arguably, if it wasn't already contracted out to Otis Elevator Company, was fulfilled. And on top of that duty, If in the fact that it is found that there is some sort of duty outside of that, we have to get to the proximate cause of the issue, the foreseeability, the cause and fact. And the cause and fact, or the foreseeability and the proximate cause of the damages of Lucero, Salceda, and Herring cannot be attributed to the CA defendants in any way, due to the fact that they are not the operational function of the elevator. Just because the elevators are on the property doesn't mean they have the ability to create the issues with the elevator, to prevent the issues with the elevator, as it was Otis's job to maintain the elevator. There's a case where it describes, basically, it recently came out in 2025, approximate cause and foreseeability, where the truck driver was driving and the car came over into the opposite side of the road, and the truck driver basically hit them because they had lost control on an icy road. In this instance, the analogy to that would be the plaintiffs were riding on an elevator managed by Otis. Just because the elevator was on the property at the time and malfunctioned under Otis's control does not mean it's the actual property manager's responsibility to ensure that a danger does not arise with the elevator.
And really, this gets down to the premises liability is, does the, and for Rio, for a property owner, we have to know about a dangerous condition, or we have to have some sort of notice of it. But Rio and the CA defendants as well, they have to be reactive. They're told that the elevator is cleared for operational use by Otis. Otis comes out, they fix the problem when there is a problem, and say the elevator's good to go. Once Otis leaves, the elevator's turned back on until something else happens. Then someone comes and say, hey, something happened on the elevator. Then the property management company, the CA defendants, will then shut down the elevator and call Otis to come back. It's not their job to second guess Otis. But for 2101 Rio, property owner, they're just the owner. They're not even communicating with Otis. They have absolutely no idea what's going on for any of this. So there's really no way for 2101 Rio, the property owner, to have been negligent or to have any knowledge of any dangerous condition, because they've contracted that entire responsibility set over to the CA entities, who then in turn have to be almost completely reactive. That really gets down to the bottom of most of what we're talking about. We're really talking about negligence, premises liability, and gross negligence here. And I would say for all three of these entities, it's impossible for them to establish the elements of any of those claims against any of 2101 Rio or the CA defendants, because this just isn't our realm. There's nothing we can do other than call Otis when a problem arises. And that's why we would ask, and we've put forth the contracts. Every single deposition in this case, the person has said, when there's a problem, you call Otis. If there's an issue, you call Otis. Margot Mendoza, who was the property manager at the time, testified that she relied on Otis's professional judgment for elevator and safety determinations. And if they deemed it operable and able to be in use, she just did what they said, because that's her job description, not second guessing anybody. So there's no evidence that didn't happen. Otis was called out to the property something like 60 times leading up to this, showing that every time someone came to the property management company would turn around and call Otis exactly like they were supposed to. So in this instance, there can be no duty, there can be no proximate cause, because we're just completely uninvolved. The only involvement is that it's in the building, but those responsibilities were shifted to the exclusive realm of Otis because they're the elevator experts.
And
So-
Judge, just on that one note regarding the contractual duty, if there was some sort of language in the contract that says Otis retains no operation or ownership over the elevator, this is solely the responsibility of the managing party or the property owner, then maybe that's a different story. But in the contract here, all of the duties, all of the management, all of the operations of the elevator are listed out in the Appendix A of our exhibit. I believe it's Exhibit 1, D001, and it states in detail how the operation, maintenance, management are all of defendant Otis's, with no retention owned by the property owner or the property management company. And plaintiff's response, their main case they rely on, cites a contract back in the 60s between Otis and another plaintiff, where that contract says the property owner maintains the management and operation of the elevator. That's not the case here. That case focuses on the reliance of the contract and the language within the contract. And that language is not present in the contract between Otis and our clients here today.
And for what it's worth, Your Honor, even if you decide that, we're correct and you dismiss our claim or their claims against us for premises liability, negligence, and gross negligence, these entities are still going to be remaining in this case because the plaintiffs, after we filed our motion for summary judgment, added a res ipsa cause of action to their claim. So they're not totally out on trying to pin liability on us, but we just think for these three causes of action that are in front of the court today, they've put forth no evidence of control, no evidence of duty, no evidence of causation, and the evidence we've put forth, the deposition testimony, all points towards this being Otis's realm.
Okay.
Your Honor, Braden Riley on behalf of the plaintiffs. Just before we get into a lot of the meat of what Mr. Sherrod was talking about, just while it's on my mind, one of the things he just mentioned is that if the court were to grant relief to these defendants today, they'd still be in this case. My understanding of res ipsa, just to be clear, is that that's an evidentiary rule, not an independent cause of action. So I'm not sure that that's how that would actually play out. And I plan to talk about res ipsa, but I just want to be clear on my perspective on that. But Judge, from our perspective, I don't think that this is a close call. I understand that Mr. Sherrod's position and Mr. Higgins' position is that this was all delegated out to Otis. Your Honor, this is an argument that's been put forth for literally 61 years since the Texas Supreme Court decided the case of Bond versus Otis Elevator. I'm sure Your Honor's seen our briefing on that. I know Mr. Higgins talked about the fact that the contractual language is different, but Judge, Bond versus Otis Elevator has been cited multiple times by Texas courts of appeals, not for any proposition as to this is what the contractual language has to say. What Bond stands for, what Bond did was the court looked at treatises on elevators and looked at the duty of a building owner or occupier with respect to elevators on its premises. And the actual language of the court in Bond, word for word, is the building's duty, which it owed to all who would reasonably be expected to use the elevators, to maintain the elevators in reasonably safe condition, cannot be delegated to an independent contractor so as to relieve the building of responsibility. That, Judge, that was an Otis Elevator case. The exact same argument was made that, look, Otis was the one that was responsible for all this. What Bond stands for is there is an absolute non-delegable duty under Texas law for somebody that operates a premises where there are elevators, that they're inviting business invitees to use as elevators. So, Judge, I think that one, the argument about duty and all these things should stop there to begin with. But we don't even have to rely on that, right? Because the facts of what we see in this case show that the property owners actually were involved in the operation of these elevators, actually did foresee these things happening, and actually had an opportunity to prevent those things from happening. How do we know that, right? So this contract with Otis provides for maintenance and repair. It does not say that we turn over this elevator wholesale. The reason for that being that these are, in fact, the elevators for the apartment complex. Of course, they're going to have a maintenance agreement where Otis comes out on service calls and things like that. 99% of the time, the apartment complex is having people ride these elevators. They're getting complaints from residents, things like that. The evidence shows, Your Honor, that the apartment complex actually had a maintenance man on site that, I think it was Mr. Sherrod that had mentioned a non-elevator person shouldn't be messing with these elevators. I agree. That's not what the evidence shows, though. The evidence shows that this person actually was resetting the elevators, and that both he and the apartment complex had the ability to shut down the elevators and had done that before. And frankly, Judge, had they done it prior to this incident, we wouldn't be here today. When we want to talk about what the apartment complex knew or should have known about these elevators, to be clear, what Otis says the industry average is 3 to 4 callbacks per year. for elevators. With these, it was 22 callbacks in a year, including a prior free fall incident a month before this. We've submitted text messages where the building management is talking about this prior free fall incident. There's evidence from the Otis technician telling us that. I asked him, I said, well, when you get a callback, what happens? And he said, we get a complaint from the building management, and then we go and we check it out and we try and diagnose it. And I asked him, what I asked him was, in all fairness, every time you go out for a service call, every time you go out to an inspection, the property owner is being made aware of the results of those things, right? And he said, yes, right? And so those 22 calls, which include multiple callbacks for the exact same thing that Otis claims, one of their people claim caused our free fall incident, the building management is getting notice of that. They're the ones that are getting the inspection reports. They're the ones that have to report to TLDR, for example. And so, Your Honor, the building management had an active role in what was going on with these elevators. Yes, they would call Otis. But again, going back to bond for 60 years, you can have joint control. And that's exactly what we had here. As far as foreseeability, again, the building management not only knew about these 22 callbacks, but in addition, the prior free fall the month before, they contact their own maintenance man about it. There's one of the text messages we submitted said, call Greg about this. And our expert has opined that the building management's failures to address the elevator issues, despite this knowledge, were both the breach and proximate cause, in addition to the failures of Otis, to directly contributing to the incident. Your Honor, I'm looking over my notes as things that Mr. Sherrod said. Additionally, one of the facts that we didn't talk about, so to give Your Honor ideas to what happened with these elevators, we don't have any of the fault data from the date of, and that's an issue that's been present throughout this case. And so our expert has opined that it could have been 4 different things. One of those things, for example, is overheating in what's called the machine room. The machine room is a room at the very top of the apartment complex. It's where all the equipment is stored. We've also submitted evidence that, and there's known equipment failures with these elevators, in particular the drive mechanism arising out of that overheating. And so we've also submitted evidence of consultants coming back in 2022 and saying, look, this was never a secret to either Otis or the building management. In the building's own machine room, where the evidence shows their own maintenance man had gone to reset this elevator before. And so the importance of that, of course, is what they're saying is they had knowledge of actual equipment failure caused by their own conditions of their own machine room dating back to, I think it was 2 years before the incident. So, Your Honor, I'm happy to answer additional questions from the court on that set of issues. But again, our overarching view of this is not a building that is just calling Otis and just walking away hands clean from it. They're actually somebody that's actively involved, has active knowledge, has the ability, and had shut down the elevators before. And frankly, had they done it here, we wouldn't be here today.
Okay. All right. Oh, Mr. Sherrod, you're on mute.
Sorry, my dogs just lost it because the mailman came up. I forgot I had it on mute. For what it's worth, James Staggs, Otis corporate representative, testified that the overheating issue would not cause a free fall. It would cause the governor to shut off, and then they would have to come back out and turn it back on. And the AAA representative, when he was testifying in his deposition, stated that yes, the apartment complex was flagged for having too much heat in there, but that did not create a safety issue in his mind. But what I think the most important thing I wanted to mention is that, yeah, he's right about this bond case, but the bond case addressed joint control between the property occupier and Otis, not an absentee property owner like 2101 Rio. Here, Rio's 3 steps removed from anything. They the people that Otis was reporting to and sending reports to were CA Ventures and Campus Acquisitions. There's no evidence of anyone from 2101 Rio Property Owner LLC ever making an appearance in this case. I don't have any emails. We don't have anyone even testifying that those people were even consulted. The only people who were on the property at any given time were the CA defendants and Otis. So I want to make sure that that distinction is clear, that between 2101 and Rio and the CA defendants, there is a bright line of, we own it, we're over here, this is just an investment. You guys can report to us whenever, but you guys handle it between you and Otis. And for, to put fault on us for, yeah, there were a lot of calls, but what's the leasing agent supposed to do about it? They call Otis, Otis comes out, makes the repair and says, you're good to go. It's not the property management or the maintenance guy's responsibility to second guess Otis and say, I don't believe you. If Otis comes out and says our elevator has been fixed, they open it. It's a 20-something story building. They have to have the elevators working. So I think that I just wanted to make those points a little bit clearer. That's all.
Your Honor, if I may respond on that. And so when we look to the fact that, I agree with Mr. Trott. I'm never going to say that I think that a person wearing a 21 Rio or 2101 Rio Grande's shirt, was there on the property doing things. Obviously, we've made the agency arguments. I stand behind those. I'm sure your Honor is aware of this. But what I want to add is when we look to whether or not something like that matters, does it matter whether or not they were physically there? The case we look to is United Scaffolding versus Levine, right? And what United Scaffolding versus Levine says is what matters is the right to control the property. It's not the physical control, right? And so what United Scaffolding versus Levine says is the premises liability defendant may be held liable if it assumed control and responsibility for the premises, even if it did not own or even physically occupy the property. And it also goes on to say that that can be expressed by contract or conduct. And so what really is at issue here is who had the right to control the property. And that's where I think that you get into these arguments about, okay, what does the agency relationship look like? We've made these arguments in our brief that they delegated out agency to these other companies. They said, look, we're going to set your duties and responsibilities. You need to follow our policies. In fact, even the Otis agreement says they got to follow the owner's policies. And we can talk about those things, obviously, in front of a jury, and a jury can decide those factual issues. But where we're at with it is simply for purposes of today, is there a genuine dispute of material fact as to who had the right to control the property between the 2101 Rio Grande and CA Ventures and Campus Acquisitions? Absolutely. I think that there is a genuine dispute of material fact. And then it's going to be up to the jury to figure out who do we think that, had that the most control, or what's the proportion of liability under Chapter 33, however they want to do it.
Judge, brief response.
Yes.
One of the key components of control is not that it can be just delegated whether somebody did or did not control somebody. There's a factor test to that, as you very well know, and as we've heard in many cases before this. And some of those factors include control of the day-to-day activities, how people were paid. Was it W-2? Was it 1099? What were the actual duties that were controlled? Were people saying, you need to open the elevator this way, you need to order this control part, you need to take out this processor? There's no evidence of any of that. There's no evidence that shows 2101 Rio or the CA defendants did anything in the operation of the day-to-day elevator activity other than to shut it down and contact Otis when there's a problem. And the case law is clear that it states in the inception of a problem, they can issue a job and they can issue things to that there needs to be work performed. But so is they're not controlling the day-to-day activities of that work. They're not telling them how to use tools. They're not telling them what tools to use. They're not telling them who to employ, when it has to be done by. They're just saying, hey, there's an issue. We've contracted you. Please fix it. That's not control. That does not operate out of control. And then the other thing Mr. Riley commented on is it can be contracted. And as we have said, there's nothing in the contract that shows that we maintained, managed, or operated the control of the elevators. That was done by Otis. And in the contract, it delineates the day-to-day activities that were issued to Otis, the operations that were issued to Otis, the things that Otis was going to be in control of and operative of regarding the elevators.
I might also add that United Scaffolding also provides that negligence and premises liability are mutually exclusive. So it pretty clearly lays out that they can only maintain one of those two causes of action, not both.
Okay, but that doesn't necessarily mean.
No,
that-
I'm asking, I want them both taken out. but
Right. Okay, but, okay,
But we did mention that in our original motion that these are mutually exclusive, and should the court decide that one theory is better than the other, that there's a basis for that. But don't get me wrong, I still want you to get rid of all of it.
okay.
And
Well,
on,
we certainly had cases where both are submitted, but only a verdict can only be entered for one
Right.
theory of recovery. I understand that.
and Judge, we have a separate complete argument after these regarding gross negligence, just because of the higher standard and the two elements there.
Okay,
And if you'd like to start on those, in terms of gross negligence, the plaintiffs offered in their response quite literally zero arguments to the traditional notion of gross negligence. It's not listed whatsoever. They talk to the no evidence portion, but they fail to even mention under the traditional standard of genuine issue of material fact. Now, that's a procedural error to which, by default, the CA Ventures entities and the 21 Rio entities we believe should win on. But if the court doesn't believe that's the case, we don't believe that the elements have been laid out for the objective or the subjective standard of gross negligence that rise to find the CA defendants liable or the 21 Rio Grande property owner liable.
okay.
Your Honor, I'm not aware of us failing to respond to anything. I think to anything, we cited evidence, which obviously would support a response to the traditional and no evidence. Also, our motion is titled response to no evidence and traditional motion. So to the extent we could have had, better subheadings, that's probably my fault. I'll fall on the sword for that. But obviously we submitted evidence in response to both. That was the intent, and that's where that's where we're at on it. A couple things with respect to gross negligence, Your Honor. One, again, I'm going to keep hammering on it because it's important. There was a prior free fall the month before with one of their residents. Let me also just put this in context for the court. What our plaintiffs are alleging happened, and what I think the evidence has shown so far, is that the elevator free fell 5 to 6 stories in a 21-story apartment building. This free fall, our free fall happens September 15, 2021. The prior free fall happens August 3rd, 2021. We have submitted text message chains between the management at the company saying, Josiah, who's the resident's name, Josiah is saying the elevator fell 5 stories. 6 weeks before, whatever that is, 5, 6 weeks before our accident, there is an allegation by another resident that the elevator fell 5 stories and then it fell again. And by the way, Judge, it's a different there's 2 elevators to the apartment complex. This is actually the 3rd time in 2 years that one of the elevators of the 21 Rio is alleged to have free fallen. We've submitted evidence of the callback records going back to 2019, where there's actually a note from the apartment complex saying free fall in those words from 2019. But I'm not even going to talk about the other elevator today. I think that evidence is relevant. I think it's before the court. If the court, wishes to look at it. Actually, I don't want to go back my word, but I will say I think that evidence is relevant to gross negligence as well, because these elevators are maintained under the same program. It's the same machine room. It's the same technicians servicing them. It's obviously the same companies that are running the apartment complex. But Judge, so we have the prior free fall. We've also briefed ratification. Obviously, nobody was disciplined or anything like that as a result of this. But at the end of the day, what the gross really looks at is obviously the subjective and the objective component. Objectively, was there an extreme degree of risk to the general public, the 300 residents getting on and off of those elevators, the 21 Rio, that there was going to be another 5 to 6 story free fall? Yes, that happened 5, 6 weeks before. subjectively, did 21 Rio act with recklessly, in reckless disregard of that risk? Yes, we know for a fact that 21 Rio had shut down these elevators before. In fact, Your Honor, we haven't talked about this either, but the evidence shows that 21 Rio was so dissatisfied with what was going on with Otis that they actually called out another consultant. And that happened before our accident, to look at these elevators. So the question is, and the question the jury's going to have to consider here is, at what point do you stop looking to somebody else and you say, look, we've shut these things down before. Yes, we have a maintenance and service contract, but we have a non-delegable duty under Texas law to maintain a safe place for all these residents with respect to these elevators. At what point do you say, hey, I'm going to shut down these elevators and make sure nobody's getting hurt, make sure we're not having 5 to 6 story free falls, 2 of them in 2 months? I think that clearly meets the elements, Judge. But again, that's for the jury to decide. We're just here to decide, teeing up that information, is there a genuine dispute of material fact?
Okay.
Judge, brief response.
Okay, I do have the other folks coming back at 3:15, so.
Okay, I was just going to say
Let's make it quick.
all of that sounds like evidence directed towards their standard claims. I don't hear a conscious indifference. In fact, I hear steps that were taken against the conscious indifference, hiring consultants, shutting down the elevators when the incidents occurred, doing what they were supposed to do, and not having somebody who was a college student go tinker with the elevator, but every time there was an incident, shut it down, direct it to Otis, hire consultants, do what they had the ability to do to correct any issue that they're citing was the fault of the defendants.
Okay. All right, anything else? Does that cover both of the motions?
We do have one other issue of a spoliation. We need a separate ruling on. There's a spoliation issue.
Okay. I highly doubt that I'm going to take that out of the trial judge's hands. But if you would like to argue it, you may do so.
I'll defer to Colin here.
Okay.
You're not inclined to entertain it, and we want to punt it for the trial judge. I'm fine with that, Your Honor.
Plaintiffs agree to that, Judge, to the extent that, yeah, I mean, we can agree to that.
Okay. I just think it's best, and it's more typical in Travis County that the judge trying the case would make any decision about whether to submit spoliation or not. So I see that your trial date is coming up in the near future, but it's probably not going to be tried with me necessarily. So because of that, I would like to, I'll make a note that that issue will be reserved for the trial judge in my docket note. But I'll take the summary judgment motions under advisement. And when a decision has been made, you'll hear from my staff. Because your trial is April 20th, is that correct?
That's correct, Your Honor.
Okay. Have you mediated the case already?
Yes, Your Honor.
Okay. All right. Just wanted to make sure, because we do require that before you get a jury trial over here. And as you know, because of the new Texas law and the government code requiring courts to consider summary judgments either by hearing or by submission within a certain time deadline, there are now many, many more of these in front of me. And so kind of the work on these motions is increased where the hours of the day have not. So I'll endeavor to get
I wasn't sure if those rules were going to be grandfathered in or just automatically apply to everything.
Well, it depends, but the actual government code changes went into effect in 2020.
No.
Those are the ones that apply to the trial courts. The
Gotcha.
rules that govern when your response and when your reply are due, those just went into effect March 1st.
Sure.
But I'm just highlighting the issue that because it's relating to the date filed and not the date you necessarily come over for hearing. Anyway, we're just spending a lot more time on these motions, and there are I think it's going to create a backlog. And so I will endeavor to get you a decision before your trial date. There's no guarantee of that, though.
I will tell you, Judge, we were here, I don't know, a couple weeks ago in front of Judge Meacham on Otis's MSJ, and she gave us the entire lay of the land for everybody that had motions set. And I mean, I knew a little bit about it, but genuinely after that hearing, I went back to my office. I was like, look, everybody needs to look at this. This is more complicated than even I imagined. So
It's a scene.
It's
I
created
don't
a
envy
lot
you.
of additional work for us to track down when the motions were filed. Have they been set? Are they set within the appropriate time period? And then, of course, with every other type of hearing, we allow people to pass by agreement. But with these deadlines in place, we can no longer just allow people to pass by agreement, because then the statutory deadlines for the court to consider by submission or hearing these motions in some cases will pass, because y'all are paying attention to your deadlines. You may or may not be as tuned in to the court's deadlines. So it just created a lot of make work, and it's something I think everybody's trying to get a hold of. So anyway, we had a hearing last week, I think, and the folks were set for trial in 2 weeks. And I don't know. They have little chance of that motion being decided. Y'all have some chance, but I would say in the last 10 days, we've probably taken 8 to 10 of these motions under advisement. Some have a 50-page summary judgment record. Some have 100 pages or more. So, and there's just still the one me. So we'll do the best we can.
Well, I appreciate it, Your Honor. Thank you so much.
Okay. All right. Well, thank you for being patient with the Zoom difficulties of the prior hearing and help. Y'all were very, very kind and trying to help our other folks get it sorted out. And maybe we'll get it sorted out when they come back here at 3:15.
Yeah, I'm hoping for the best. I think she'll figure it out.
Yeah, hopefully so. So you are all excused from the virtual courtroom, and good luck with your trial in April.
All right. Thank you so much, Your Honor. Have a great day.
Thank you,
Okay.
Your Honor.
Have a good day. Thank you, Your Honor.